4,000 years ago, a single stone slab began shaping the world you live in today. Ancient law codes did not just command armies or tax the wealthy. They reached into the homes of ordinary people, deciding who you could marry, how you could do business, and what happened if your neighbor stole your goat. By the end of this, you will understand the invisible legal architecture built by our ancestors that still supports your daily life. We will uncover why a Babylonian king's rules for settling debts are echoed in your mortgage agreement, and how Roman laws about buying bread influence modern consumer rights. What part of your own life do you think is most shaped by rules written in stone ages ago? That stone slab stood in the center of a bustling Mesopotamian city around 1750 BCE. Towering over the marketplace, the black diorite monument was covered in meticulously carved cuneiform script. This was the code of Hammurabi, and its public display was a revolution. For the first time, the rules of society were not just the spoken word of a local chieftain or the shifting traditions of elders. They were fixed in stone for all to see. This shift from oral tradition to written code was one of humanity's most profound leaps. It meant that a merchant from another city could know the same rules applied to him as to a local farmer. It created a single standard of justice, aiming to unify a vast and diverse empire under a predictable legal framework. Before this, justice could feel arbitrary, changing with the mood of a ruler or the memory of a community. The code introduced a radical idea: predictability. A farmer who had a dispute with his neighbor over a damaged irrigation ditch could now know in advance what the judgment might be. The famous principle of an eye for an eye was not merely about brutal retaliation. It was about proportional justice, a limit on vengeance. If a builder's poorly constructed house collapsed and killed the owner's son, then the builder's own son could be put to death. This seems harsh to modern sensibilities, but its intent was to establish a clear, fixed price for wrongdoing, removing the chaos of personal feuds. The very act of inscribing these laws on durable stone and displaying them in public squares was a powerful statement. It declared that the law was permanent and it was for everyone. It fostered a new kind of social order, one based on published rules rather than hidden decrees. This public nature also spurred the development of literacy, as scribes were needed to read the codes to the largely illiterate population. Imagine a typical scene: two merchants arguing over a shipment of copper that arrived damaged. Instead of a shouting match or an appeal to a biased local authority, they could go to the stele. A scribe would read aloud the relevant clause, perhaps one stating that a carrier was not responsible for goods lost to robbery by force, but was liable for simple theft. The dispute was settled not by strength but by a pre-existing known rule. This ancient desire for predictable fairness still echoes in our lives today. When you read the terms of service for a new app, or when a judge consults a legal statute before making a ruling, you are experiencing the legacy of that first stone stele. How does knowing a rule is written down change your feeling of security? Does a published law feel more fair to you than a decision made behind closed doors? The Code of Hammurabi contained 282 such rules, covering everything from property and trade to marriage and inheritance. That public stele was more than a monument, it was a working tool for justice. In an age before widespread literacy, how did a king ensure his laws reached every farmer, merchant, and artisan? The answer lay in the human voice and the central square. Official readers, akin to town criers, would stand before the carved stone and recite the laws aloud, translating the dense cuneiform into the common tongue. This practice transformed the law from a silent text into a living, spoken promise that everyone, regardless of their ability to read, could understand and invoke. The location was always deliberate: the marketplace where deals were struck, the temple steps where oaths were sworn, the city gate where travelers entered. These were the hubs of daily life, ensuring the law was woven into the fabric of the community. This accessibility was a powerful check on authority. A corrupt official could not easily twist a rule that dozens of commoners had heard proclaimed in the open air. Historians note this transparency was fundamental to building trust, the first step in convincing a diverse population that the legal system existed for their benefit, not just for the ruler's control. The materials themselves told a story of permanence and purpose. In Mesopotamia, laws were carved into durable diorite, a message meant to last for centuries. In Egypt, they might be written on papyrus scrolls stored in administrative centers, but copies were still publicly displayed for reference. These texts also became the foundation of scribal education, ensuring that each new generation of administrators learned the letter of the law. Imagine a farmer, we will call him Damu, who feels a local tax collector is demanding more grain than the code allows. In earlier times, he might have grumbled and paid, powerless against an official's word. But now, armed with knowledge he gained in the marketplace, he could challenge the demand. He could point to the steal or find a scribe to read the relevant clause and assert his rights. This was a revolutionary shift in power, giving a common person a documented standard to which he could hold his leaders accountable. It established that the law was a shield for the powerless, not just a sword for the powerful. Can you think of a modern equivalent, a public document or a digital platform, where you can look up the rules that govern your rights in a dispute? This ancient principle of public access created a framework for a shared society, but it also revealed a profound tension. For within these same codes, the idea of shared justice often collided with the stark reality of social hierarchy. But that shield of justice was not forged from a single piece of metal. The same stone that promised fairness to a farmer like Damu also carved society into rigid layers. If you were a nobleman and you struck someone of equal status, the law demanded a public beating. But if you struck a commoner, your penalty was a simple fine of silver. This was the second principle etched into the stone: social hierarchy, and it was as fundamental to the legal system as the idea of written rules themselves. Ancient law codes did not invent class distinctions, but they gave them the powerful force of law, making social status a legal fact that dictated your entire life. Your value in the eyes of the court, the compensation you received for an injury, and even whom you were permitted to marry were all predetermined by the class you were born into. A noble, an awilum, lived under one set of rules, a commoner, a muskinum, lived under another, and a slave, a wardum, existed in a category with painfully few rights at all. These were not vague social labels, they were precise legal definitions that governed everything from the marketplace to the bedroom. Anthropologists see this as a tool for political stability. By formally recognizing and regulating the existing social order, a king could secure the loyalty of the powerful noble classes while still providing a basic, if unequal, framework for the masses. It was a system designed to prevent chaos, but it inherently perpetuated deep inequality. Take the rules of inheritance, for instance. A nobleman's estate would pass to his sons, ensuring wealth and power remained concentrated within the elite. A commoner might inherit his father's tools and a small plot of land, but his legal ability to challenge a noble was severely limited. For a slave, inheritance was virtually non-existent, as they were often considered property themselves. Labor obligations were also legally enforced. A commoner might be required to provide a set number of days of labor on public projects for the state, a form of early taxation. A nobleman's obligations were different, focused on military service or administrative duties. This legal codification of labor ensured the state's infrastructure and army were maintained by a predictable, class-based system. Consider the vivid reality of a lawsuit. Two separate assaults occur on the same day. In the first, a merchant strikes another merchant during a heated negotiation. The case goes before a judge who consults the steel and orders the offender to pay 60 shekels of silver to the victim, a significant but manageable sum for a man of trade. In the second case, a laborer, enraged by his treatment, strikes the same merchant. The judgment is swift and brutal. The laborer's hand could be cut off. The same action, striking a person, resulted in wildly different punishments because the law cared less about the act itself and more about the social standing of the people involved. This principle extended into family life. Marriage between a noble and a commoner was often legally complicated, sometimes resulting in the children holding a lower status. The law actively policed the boundaries of class, ensuring that social mobility was nearly impossible. Can you perceive the faint echoes of this in our own world, where access to wealth can sometimes influence the quality of legal representation and the outcome of a case? The ancient codes made explicit what often remains implicit today. They built a world where your birth was your destiny, a destiny enforced by the full weight of the law. This legal architecture of class was just one pillar supporting the ancient state. The other was an emerging set of rules that would forever change how humans conduct business, governing everything from the price of bread to the interest on a loan. Those rigid class distinctions were just one side of the legal coin. The other side was stamped with the image of commerce. In the very same marketplace where the laws were proclaimed, a different kind of order was being enforced, one that dealt not in social status but in silver and grain. While your birth might determine your value in a court of law, the king's code aimed to ensure that a shekel of silver was a shekel of silver for everyone. This was the third great principle, the legal governance of the economy, and it was the engine that powered the ancient world. Long before central banks or federal trade commissions, rulers understood that economic chaos could topple an empire faster than any invading army. The Code of Namu, one of the oldest known legal systems, set official limits on interest rates for loans. Imagine the stability this provided. A farmer needing to borrow seed grain before the planting season could know the maximum interest a lender could charge, preventing him from falling into a debt spiral from which he could never escape. This was not mere kindness, it was brilliant statecraft. A population free from crippling debt was a stable, productive population. Roman law later perfected this with intricate rules for contracts, sales, and partnerships. A Roman merchant could form a societas, a legal partnership, with an investor to fund a trading voyage to Egypt. The contract, written on papyrus and witnessed, clearly outlined how profits and losses would be shared. This legal framework allowed strangers to pool their resources and take calculated risks, fueling the expansion of trade across the Mediterranean. The law provided the trust that enabled commerce to flourish over vast distances. But how was this trust maintained in the crowded, chaotic daily market? The answer often came down to something as simple as a weight. Official stone weights bearing the seal of the king were kept in the marketplace. A baker accused of selling underweight bread would have his loaves weighed against this public standard. If found guilty, the consequences were severe and public. He might face a hefty fine or even have his hand struck for repeated offenses. This was not just a punishment, it was a performance of justice designed to reassure every other customer that the system worked. Public inspectors patrolled the markets, and disputes between merchants were settled in courts that referenced these written commercial laws. A trader who received a shipment of spoiled wine could sue the shipper, not based on a personal grievance, but on a violation of a known standard for transporting goods. This entire legal architecture, from interest caps to standardized weights, created a predictable environment where business could thrive. It fostered the confidence necessary for a merchant in Babylon to send his goods to a partner in a distant city, trusting that a common set of rules would protect his investment. Can you see the direct line from those ancient market inspectors to the modern regulations that ensure the food in your grocery store is safe and the weight on the package is accurate? This web of economic law stabilized societies and connected empires, but it reached even deeper into the most intimate spaces of human life, the family home. Beyond the bustling markets and public courtrooms, the law's longest shadow fell within the quiet of the family home. A wedding in ancient Babylon was not merely a celebration, it was the signing of a binding contract that defined your entire future. These law codes reached into the most intimate corners of life, meticulously structuring marriage, divorce, and inheritance to create a predictable and patriarchal social order. The rules governing a family were as detailed and enforceable as those governing the price of barley. A marriage contract was a business arrangement between families, specifying the dowry the bride brought from her father's house and the bride price the groom's family offered in return. This exchange was not symbolic, it was a legal transfer of property that secured the woman's future. If the husband later sought a divorce without proper cause, he was legally obligated to return the dowry, providing her with a crucial financial safety net. Yet this protection existed within a system that overwhelmingly favored male authority. A wife accused of adultery could face the death penalty, often by drowning, while a husband's infidelity was typically treated as a minor offense. Scholars point out that these laws were designed to ensure the legitimacy of heirs and the stable transfer of property from one generation of men to the next. A woman's primary legal value was often tied to her role as a mother of sons. Consider the stark reality for a childless widow. Her husband's family might try to claim the property she had helped build, leaving her destitute. But the codes often provided a narrow path for justice. She could go before the elders at the city gate and present her marriage contract, demanding the return of her dowry, which was legally hers. This was a personal, high-stakes legal battle where her entire security hinged on the words carved into a stone decades earlier. The law's grip extended to children as well. Adoption was a common and legally intricate practice, especially for couples without an heir. A man could adopt a male child, and that child would then have the same inheritance rights as a biological son, a vital measure for continuing the family line and its obligations to the state. Parental authority was absolute, a concept known as patria potestas in Roman law, which gave a father the legal right to control his children's lives, including their marriages and property, even into adulthood. Yet these rules were not monolithic across empires. The Hittite laws, for instance, offered women somewhat more freedom in managing their own property, while the Assyrian codes were notoriously harsh, even dictating how a wife must veil herself in public based on her social rank. Can you trace the echoes of these ancient contracts in modern prenuptial agreements or inheritance disputes? The legal architecture of the family was the bedrock of society, ensuring that property, the ultimate source of power, remained controlled and passed down according to a strict state-approved plan. That farmer in Egypt clutching his land deed held more than a piece of papyrus. He held a promise from the state itself, a guarantee that the field he had spent his life cultivating belonged to him. This was the fifth pillar of ancient legal architecture, the establishment of property rights, and it transformed how people related to the world around them. For the first time, your claim to a piece of land, your house, or even your tools could be defended not just by your own strength, but by the full authority of the king's code. This legal concept was revolutionary. It meant that a farmer could invest in improving his land, perhaps building a new irrigation channel or planting an orchard, secure in the knowledge that he would reap the long-term benefits. Economic historians point to this security as a primary driver of agricultural innovation and wealth creation. Without it, why would anyone build a better barn if a powerful neighbor could simply seize it tomorrow? The law created the stability necessary for long-term planning. This principle was articulated with stunning clarity in Roman law as dominium, the ultimate right to use, enjoy, and dispose of property. It was a powerful idea that an object or a piece of land could have a single, legally recognized owner whose rights were superior to all others. But how was this abstract idea enforced in the messy reality of daily life? The mechanisms were surprisingly sophisticated. Land transfers required formal contracts, often inscribed on clay tablets or papyrus, and witnessed by multiple community members. These witnesses were not just a formality, they were a living record. If a dispute arose years later, they could be called upon to testify about the exact terms of the sale. For leasing, the code set out detailed rules. A tenant farmer might lease a field for a share of the harvest, perhaps 1/3. The contract would specify who provided the seed, who maintained the irrigation ditches, and what happened if the crop failed due to drought. These clear expectations prevented countless conflicts. Imagine a simple boundary dispute between two neighbors, a story as old as settled agriculture. One farmer, we will call him Keti, notices his neighbor, Sabu, has moved the stones that mark the edge of their fields, encroaching on his land. In an earlier time, this might have led to a bloody feud. But under the pharaonic decrees or the code of Hammurabi, Keti had a path. He could take his deed, gather his witnesses, and bring the case before the local council. The officials would investigate, perhaps even measuring the fields against the original survey records. If Sabu was found to have stolen the land, he would be forced to return it and pay a significant fine, often multiple times the value of the stolen produce. This system replaced violence with procedure. The penalty for stealing personal property was equally severe. A thief caught stealing a shovel or a valuable pot could be forced to repay 10 times its value, or in some cases, face physical punishment or even death. The law made the cost of theft so high that it acted as a powerful deterrent, protecting the possessions of common people and elites alike. Can you see how the title to your own home or the registration of your car is a direct descendant of these ancient deeds? That piece of paper is your modern-day link to a system designed to turn physical possession into a legally defendable right. This intricate web of property law created order and fostered prosperity, but it also required a parallel system to address its most serious violations, a system that would define the very meaning of crime and punishment. A courtroom in ancient Babylon was a theater of legal certainty. There, a judge would not rely on personal whim, but would consult the public stele to determine the precise penalty for a thief. This was the sixth foundational principle, a system of criminal justice and punishments designed to replace chaotic vengeance with predictable, state-sanctioned consequences. The goal was twofold: to deter others from wrongdoing and to ensure that retribution or payment was delivered according to a fixed standard. The most famous expression of this was lex talionis, the law of retaliation, often summarized as an eye for an eye. To our modern ears, this sounds brutally harsh, but in its original context, it was a revolutionary limit on violence. It meant that if a man caused another to lose an eye, the punishment could not exceed the loss of his own eye. It prevented a family from demanding a life for an eye, stopping blood feuds before they could spiral out of control. This principle of proportional justice was paired with a more familiar concept, compensatory justice. For many property crimes, the solution was not physical mutilation but financial restitution. A thief caught stealing an ox might be forced to repay 30 times the animal's value. This hefty fine served as a powerful deterrent while also making the victim whole. Different legal codes applied these principles with varying severity. The Roman 12 tables, for instance, allowed for personal injury claims where the victim could negotiate a compensation payment with the assailant. If they failed to agree, the law permitted literal retaliation, a life for a life. This system acknowledged the victim's right to justice while offering a financial path to avoid further violence. Crimes were carefully categorized. Assault, theft, and murder were obvious offenses, but the codes also addressed more subtle crimes like perjury. Bearing false witness in a capital case could result in the liar being put to death, a stark reminder of the legal system's demand for truth. Adultery was treated not as a private betrayal but as a severe social crime that disrupted bloodlines and inheritance, often punishable by death for both parties. The procedures for proving a crime were just as important as the punishments themselves. The codes created a framework of evidence, a shield against false accusations. Imagine a merchant in Lil Bani, accused by a rival of failing to repay a silver loan. The accuser brings the case before the elders at the city gate. But Lil Bani produces his clay tablet contract, signed by witnesses, showing the debt was paid in full on the agreed date. The case collapses. Without that written proof, he might have been forced into slavery to settle the alleged debt. This requirement for evidence, for witnesses and documents, was a critical step toward fairness, protecting individuals from malicious claims. How does the burden of proof in our modern courts, where the accused is innocent until proven guilty, reflect this ancient desire for procedural fairness? The evolution of punishment methods reveals a society grappling with the purpose of justice. While capital and corporal punishments were common for severe crimes, the widespread use of fines for minor offenses shows an understanding of restorative measures. A man who accidentally caused a fire that burned his neighbor's shed would not lose his hand, he would pay to rebuild it. This focused on repairing the harm rather than merely inflicting pain. These ancient courtrooms, with their standardized penalties and evidence rules, were building a new idea that the state, not the individual, held the primary authority to punish. This monumental shift created the foundation for all modern criminal law. Yet for every dramatic criminal trial, there were 100 quieter disputes between neighbors over a broken fence or a misplaced boundary stone, conflicts resolved not by punishment, but by a different branch of the law entirely. While the criminal court dealt in punishments, the daily life of a community was more often shaped by the quieter realm of civil law. This seventh principle governed the disputes that arose naturally between people, the broken contracts, the property damage, and the personal injuries that were not crimes against the state, but conflicts between neighbors. Here, the goal was not punishment, but resolution, a peaceful way to settle a claim and restore balance without violence. In ancient Athens, a specialized public official known as a public arbitrator was appointed to mediate such disagreements. His role was not to command, but to listen, to review the written laws or customary rules, and to help the parties find a fair solution. This system recognized that a forced judgment could leave lasting resentment, while a mediated agreement could heal a social rift. Legal historians note that this focus on procedural fairness, on giving each side a chance to be heard, was crucial for social cohesion. It allowed a complex society to function by providing a reliable alternative to the feud. The types of cases were endlessly varied. A farmer might sue his neighbor for allowing his livestock to trample a barley field. A shipowner might bring a case against a merchant who refused to pay for a delivered cargo of olive oil. These were torts, civil wrongs that required compensation, not imprisonment. The adjudicators could be royal judges, a council of village elders, or in some Greek city-states, large citizen juries. Their authority came from the legal code, which provided the framework for their decision. Evidence was paramount. A plaintiff bringing a suit for breach of contract had to present his evidence, which could be the clay tablet contract itself, the testimonies of witnesses, or even physical objects. In cases with little physical proof, the law often turned to the divine. Parties might be required to swear a solemn oath before the gods, affirming their version of events. It was believed that a person willing to commit perjury in such a sacred act would call down divine wrath upon themselves, a powerful psychological deterrent in a deeply religious society. Enforcement was the final, crucial step. A judgment was useless if it could be ignored. The codes gave the state the power to enforce civil rulings. If a man was ordered to pay 20 shekels of silver for a breach of agreement and refused, the court could authorize the seizure of his property or even his own person to satisfy the debt. This state-backed power transformed a recommendation into a binding order. Consider the Mesopotamian edicts known as Misharim, acts where a new king would proclaim a clean slate, canceling certain types of private debts. This was a radical form of civil law intervention from the top, designed to prevent a debt crisis from tearing the society apart. It freed debt slaves and returned pledged land, a reminder that the law could be a tool for economic reset and social stability. Imagine a specific case. A Babylonian merchant, Nadin, hires a carpenter to build a new stall in the marketplace. They agree on a price and a completion date, sealing the contract with witnesses. The carpenter fails to finish the work on time, causing Nadin to lose sales during a major festival. Nadin does not resort to threats. He gathers his copy of the contract and his witnesses, and he brings a civil suit before the judges. The carpenter is found liable for the losses. The court orders him to complete the stall and to pay Nadin a sum of silver equal to the estimated lost income. The process is orderly, accessible, and grounded in the published law. How many minor conflicts in your own life, from a dispute with a landlord to a disagreement with a contractor, are resolved through similar civil mechanisms rather than personal confrontation? This entire architecture of dispute resolution, however, often drew its ultimate authority from a source beyond the king or the community, from the realm of the gods themselves. But the authority of a judge or a king was often seen as merely an echo of a higher power. The laws governing your neighbor's fence or your business contract were frequently believed to originate with the gods themselves. This eighth principle, the religious and moral foundation of law, wove spiritual duty and legal obligation into a single, unbreakable thread. For many ancient societies, a legal breach was not just a crime against your neighbor, it was a sin against the divine order, an act that could bring misfortune upon the entire community. The Hebrew Torah provides a profound example where the laws given to Moses on Mount Sinai seamlessly blend detailed civil statutes about property and restitution with profound moral commandments like "you shall not steal" and "you shall not murder." Here, the rules for building a parapet on your roof to prevent someone from falling were placed right alongside the laws for observing the Sabbath. There was no distinction between the secular and the sacred. The law was a complete guide for living a life that was both socially harmonious and spiritually pure. A king like Lipit Ishtar of Sumer began his law code by stating he was chosen by the gods to establish justice in the land. This divine mandate provided an unshakable legitimacy, making disobedience not just a political offense but an act of impiety. The Hindu text, the Manusmriti, framed its extensive social and legal rules as the divine laws of Manu, the progenitor of humanity, prescribing everything from dietary restrictions to the duties of a king. Compliance was encouraged not only by the threat of earthly punishment but by the promise of spiritual consequences, both in this life and the next. This integration was visible in the most routine aspects of life. Take the enforcement of Sabbath laws in an ancient Israelite village. As the sun dipped below the horizon on the sixth day, the entire rhythm of the community shifted. Work ceased completely. A farmer could not light a cooking fire. A merchant could not open his shop stall. This was not a matter of personal choice. It was a legally enforced religious observance. If a man was caught gathering wood on the Sabbath, the community was obligated to bring him before the assembly, and the penalty could be severe, even death by stoning. This seems extreme to us now, but for that community, his action was a direct defiance of a divine command that threatened the spiritual safety of everyone. His personal sin became a public legal matter. Other codes were filled with similar intersections. Blasphemy or showing disrespect to a god was a capital crime in many cultures. The amount of grain you were required to offer to the local temple was often specified right in the legal code, a tax owed to the divine king. Purity laws governed who could enter sacred spaces and under what conditions, creating a legal framework for spiritual cleanliness. How does this ancient fusion of law and morality compare to modern debates about the proper relationship between religious values and state legislation? The idea that the law should enforce a specific moral code remains a powerful and contentious force in our world. This divine legitimacy gave the law immense power, but it also created a system that required a sophisticated and permanent administrative class to interpret, record, and enforce its will across a growing empire. A king's command was powerless without the scribes and officials who gave it force. This ninth principle, the rise of a legal bureaucracy, transformed grand pronouncements into the daily reality of governance, managing everything from the grain in the royal storehouse to the soldier in the field. In ancient China, the Qin dynasty perfected this system, using a comprehensive legal code known as legalism to administer a vast empire. The law did not merely punish crime, it defined the very duties of the state. It set tax rates on agricultural harvests, mandated periods of conscription for military service, and organized massive public works projects like roads and canals. Every official, from the highest minister to the lowliest provincial clerk, operated within a strict hierarchy defined by legal statutes, their responsibilities and limits clearly written down. This created a predictable, impersonal administration that could function regardless of the emperor's personal attention. The Persian Empire, stretching from the Indus Valley to the Aegean Sea, relied on a similar legal and administrative framework. Satraps or provincial governors were bound by royal law to collect a set amount of tribute and to provide soldiers for the army. Imperial inspectors, the eyes and ears of the king, traveled the royal road to ensure these officials were governing justly and not lining their own pockets. This system of accountability, written into law, was the glue that held diverse cultures together under a single rule. The law mandated meticulous record-keeping. A census was not a modern invention, it was an ancient legal tool. The Inca Empire, without a written language, used knotted strings called quipu to track population numbers, labor obligations, and warehouse inventories. This data was the empire's legal and economic nervous system, allowing for the redistribution of resources from fertile valleys to mountainous regions, preventing famine and ensuring stability. In Egypt, the vizier, the pharaoh's chief minister, was the living embodiment of this principle. He did not rule by personal whim. He applied the pharaonic decrees to settle disputes, oversee the grain tax, and manage the thousands of laborers who built the monuments. His authority was derived from and constrained by the published law. Consider the practical reality in a small village dependent on a single river. The local irrigation code, based on royal decree, specified exactly when each farmer could open the water channels to his field and for how long. A council of elders enforced these rules, resolving disputes before they could escalate. A farmer who tried to take more than his allotted share was not just being selfish, he was breaking the law and threatening the food supply of the entire community. His fine was not a punishment for the sake of punishment, but a legal mechanism to restore balance and protect the common welfare. This entire administrative superstructure, from the vizier's court to the village council, existed to translate the abstract idea of the state into tangible order and security. How much of the efficiency or inefficiency of our own modern governments can be traced back to these ancient blueprints for bureaucracy? The same legal codes that organized these vast public works and tax collections also had to govern the people who performed the labor, often drawing a stark line between the free citizen and the enslaved worker. The legal bureaucracy that managed grain taxes and irrigation schedules also governed the most intimate relationship of power, that between a master and a slave. In the stark hierarchies of the ancient world, a slave was legally defined as property, a living tool with few personal rights. Yet even here, the written codes carved out surprising spaces for protection, creating a system of profound ethical contradictions. The Roman law of peculium, for instance, allowed a slave to manage and eventually purchase his freedom with savings he accumulated, a legal mechanism that acknowledged a slave's capacity for enterprise while reinforcing the master's ultimate ownership. This was not born of kindness but of economic pragmatism. A slave with a path to freedom was a more productive and less rebellious asset. The laws of Eshnana, centuries earlier, set specific monetary values for labor, establishing wages for free workers like boat builders and field hands. This created a legal marketplace for work, distinguishing the free laborer who sold his time from the enslaved person who was himself a commodity. But the code's humanity had sharp limits. A provision for a runaway slave mandated a hefty reward for their capture, a powerful incentive for anyone to return human property to its owner. The punishment for harboring a fugitive could be severe, underscoring the law's primary role in protecting the economic interests of the slave-holding class. In the Greek city-states, disputes over a slave's treatment could sometimes reach the courts. A master who brutally abused his slave might face public censure or, in rare cases, be forced to sell the individual, not out of compassion for the slave, but because such excessive cruelty was seen as a disturbance of the public order. Social historians see these rules as a tense negotiation between absolute power and social stability. Unchecked brutality could lead to slave revolts that threatened the state itself, so the law stepped in to regulate the very exploitation it permitted. Imagine a specific legal hearing in Rome. A slave named Marcus, who has been trained as a scribe, approaches a magistrate. He is not pleading for better food or less work. He is presenting a legal petition for his freedom, citing a clause in the city's statutes that grants liberty to any slave who reveals a conspiracy against the state. His master is furious, arguing that Marcus is his valuable property. The magistrate, bound by the written code, must weigh the claim. The law, in this moment, becomes a shield for a man it otherwise defines as a mere object. This complex reality forces us to ask difficult questions. How do we reconcile a legal system that could both deny a person's humanity and offer them a procedural path to reclaim it? Can you see the long, slow echoes of these ancient labor regulations in modern struggles for workers' rights? and the ongoing fight against exploitative practices. This intricate legal framework governing labor and status was mirrored by an equally complex set of rules applied to another vast segment of the population, one whose legal identity was often defined by their relationship to men, their fathers, and their husbands. A widow in ancient Rome could possess a level of financial independence that would be remarkable for centuries to come. Under laws like the Ius Liberorum, a free-born woman with 3 children, or a freedwoman with 4, could gain the right to manage her own financial affairs without a male guardian. This was just one thread in a complex legal tapestry defining women's lives, a status that varied wildly from being treated as near property to holding significant personal agency. The law was the ultimate architect of these gender roles, meticulously constructing the boundaries of a woman's world through statutes on marriage, money, and motherhood. In many societies, a woman lived under perpetual guardianship, first her father's, then her husband's. In classical Athens, a woman known as a Kyrios had to represent her in all legal and financial transactions, from selling a piece of land to signing a contract. She was a legal minor for her entire life, yet just across the Mediterranean, an Egyptian woman could own property, initiate a divorce, and be a partner in a business venture, her legal voice recognized in its own right. Feminist scholars point to these Egyptian legal traditions as a powerful exception, where women could sue and be sued, make wills, and even serve as priests, their economic activities documented in countless papyri. The laws of marriage were the primary framework for a woman's economic life. A dowry was not a gift, it was a critical financial transfer from her father's family to her husband's, intended to support her for life. If the marriage ended through divorce or her husband's death, the law often stipulated the dowry must be returned, providing her with a vital safety net. This was her capital, her leverage, and her security. Inheritance laws further shaped her destiny. A daughter might receive a share of her father's estate, but it was frequently smaller than her brother's portions, designed to keep the bulk of the family's wealth in male hands. The penalties for offenses against women also revealed their perceived value. Assyrian law was brutally clear about adultery, prescribing death for an unfaithful wife, while often allowing her husband similar freedoms. This double standard was legally encoded, treating a woman's fidelity as a matter of property rights to ensure the legitimacy of heirs. Yet even within these harsh frameworks, women found ways to exercise agency. Picture a Babylonian widow, we will call her Inanna, whose husband has died without a clear will. His brothers arrive to claim the family's workshop, intending to send her and her children away with nothing. But Inanna goes to the city elders. She presents her marriage contract and calls witnesses to testify that her husband had verbally promised her the business. The elders, consulting the code, rule that the workshop must remain with her to support her and her children, recognizing her role and her children's future over the claims of distant male relatives. Her story is one of thousands, a quiet legal battle where a woman used the system to secure her family's survival. How far have we truly come in disentangling legal personhood from gender? When you consider modern prenuptial agreements or custody battles, can you see the ancient roots of these conflicts over control and autonomy? The legal status of children, the next generation, was similarly defined by a stark blend of absolute power and nascent protection, setting the stage for how societies would educate their future citizens. A child's first lesson in law came not from a classroom, but from the authority of their own father. In the rigid legal structure of the Roman household, the paterfamilias held the power of life and death over his children, a concept known as patria potestas. This absolute control extended to a son's property, his choice of marriage, and even his adult life. creating a world where a man of 50 could legally be subject to his 80-year-old father. Yet this stark power existed alongside legal mandates for care and protection, revealing a complex system designed to mold the next generation of citizens. The law did not see childhood as we do today, a prolonged period of development and learning. Instead, it defined a child primarily as a legal minor, a person under the authority of another, whose primary purpose was to ensure the family line and its obligations to the state continued unbroken. This focus on continuity made inheritance laws critically important. A father's estate would typically pass to his sons, but the codes provided intricate rules for when a father died without a clear male heir. In such cases, daughters could sometimes inherit, though their control over the property was often transferred to their husbands upon marriage. The true test of a legal system's humanity, however, was its treatment of orphans. A child without a father was legally adrift, vulnerable to relatives who might seize the family property and leave the child destitute. The Code of Hammurabi contained specific provisions to prevent this, appointing a guardian from the mother's family or the community to manage the orphan's inheritance until they came of age. This was not mere charity. It was a state interest in preventing the collapse of a productive household and the creation of a burden on the community. The journey of an orphan, let us call her Shulgi, illustrates this protective framework. When her merchant father dies on a trading expedition, her uncles arrive to take control of his lucrative business and home. They tell Shulgi and her mother they will be cared for, but offer no account of the estate's value. Shulgi's mother, remembering the proclamations at the city gate, petitions the local assembly. The judges consult the code and appoint an independent guardian, a respected scribe unrelated to the family, to inventory the property and manage it for Shulgi's benefit until she marries. The law, in this instance, becomes her shield, ensuring her father's wealth secures her future rather than enriching greedy relatives. Beyond inheritance, the law also shaped a child's path through education and apprenticeship. In Mesopotamia, the state had a direct interest in training scribes, the essential administrators of the empire. Laws supported the adaba, or tablet house, where boys from wealthy families learned the intricate cuneiform script. Their training was a form of legal contract, often paid for by the family, binding the student to a master scribe for years of rigorous instruction. Similarly, a craftsman taking on an apprentice would have a formal agreement outlining the term of service, the skills to be taught, and the obligations of both parties. The Spartan agoge represents the most extreme form of state-mandated upbringing, where the law removed boys from their homes at age 7 to be raised in military barracks, their entire childhood legally dedicated to producing ideal soldiers for the state. Penalties for neglecting these duties could be severe. A father who failed to provide his son with a trade could be penalized, as the son's future ability to support himself and pay taxes was a matter of public concern. Conversely, a master who abused his apprentice could face lawsuits and fines, as the law sought to protect the investment in a skilled future worker. The definition of the age of majority varied, but it was always a pivotal legal moment. In Roman law, a boy formally came of age by laying aside his childhood toga and putting on the plain toga of a man, a ceremony that transformed him from a legal subject into a legal person with his own rights and responsibilities. How much of our own modern framework for child welfare, from inheritance courts to mandatory education laws, is a refined echo of these ancient attempts to balance parental power with societal need? The same legal codes that sought to protect vulnerable children also extended their reach to regulate the physical health of the entire community, creating the world's first public health ordinances. The health of a city was measured not just by its wealth, but by the cleanliness of its water, Ancient lawmakers understood that a plague could cripple an empire faster than any army, leading them to inscribe public welfare into the legal code itself. This was the 13th principle, the law as a shield for communal health, governing everything from the surgeon's scalpel to the contents of a butcher's stall. The famous Hippocratic Oath was more than a moral promise. It was a precursor to medical malpractice laws, establishing a legal and ethical standard for physicians. A doctor who performed a risky procedure without his patient's consent could face legal action and social ostracism. In India, the Arthashastra mandated that physicians who made errors in treatment be fined, a direct state intervention to ensure a basic standard of care. The law's reach extended to the streets, with detailed regulations for waste disposal. Cities like Mohenjo-Daro in the Indus Valley were built with sophisticated drainage systems, and maintenance of these channels was a legal obligation for homeowners. Ignoring a clogged public drain was not just a nuisance, it was a punishable offense because one person's negligence could lead to a neighborhood-wide outbreak of cholera or dysentery. Public health historians point to these codes as the earliest recognition of a state's responsibility for the physical well-being of its population. This sense of collective responsibility is vividly clear in laws concerning food safety. Imagine a baker in a Roman market, we will call him Lucius, who sells bread made from grain that has begun to mold. A customer falls ill, and the case is brought before the aediles, the officials in charge of the marketplace. They inspect his shop, find the spoiled grain, and under Roman law, Lucius faces a severe fine and the very public destruction of his remaining stock. This was not merely a punishment, it was a performance designed to reassure every other customer that the system was watching. Market hygiene was legally enforced. Butchers were required to operate downstream from the main city to keep tainted blood and offal out of the water supply. Inns were subject to inspection to ensure they provided clean bedding and did not become centers of disease. When epidemics struck, these legal frameworks allowed for drastic action. During outbreaks of plague, city-states issued quarantine decrees, legally isolating the sick and restricting movement from affected regions, a desperate but necessary use of state power to protect the many. The law even governed the final disposition of the dead, with strict rules on burial locations to prevent the contamination of groundwater. Can you see the direct lineage from these ancient market inspectors to our own food safety agencies and public health departments? The same logic that fined a baker for moldy grain now regulates the temperature of your restaurant refrigerator. This legal architecture for public welfare did not stop at the city walls, however. It extended out into the fields and forests, governing humanity's relationship with the very resources that sustained life. A river's flow was a matter of life, death, and law. Ancient societies recognized that their survival depended on the fragile balance of the natural world, leading them to encode principles of environmental stewardship and resource management directly into their legal systems. This 14th pillar of ancient law governed water, forests, and land with a clarity that feels strikingly modern, aiming to ensure sustainability and prevent the conflicts that scarcity inevitably breeds. In the arid landscapes of Mesopotamia, the Code of Hammurabi contained detailed clauses on irrigation, making a farmer legally responsible for maintaining the canals that ran through his land. If his negligence caused a breach that flooded his neighbor's field, he was required to compensate the neighbor for every bushel of grain lost. This was not merely a rule about property damage. It was a law designed to protect a shared, vital resource for the entire community. Similarly, Mosaic law in the Hebrew Bible mandated letting agricultural land lie fallow every 7th year, a practice that allowed the soil to recover its nutrients. demonstrating an early understanding of long-term ecological health. The management of water was often the most critical legal issue. In ancient Peru, communities high in the Andes developed a sophisticated system for allocating mountain spring water, especially during droughts. A local council operating under long-standing customary law would determine the exact order and duration each farmer could divert water to his terraced fields. This legal framework transformed a potential free-for-all into an orderly, predictable process that ensured the entire community could survive a harsh season. The penalty for stealing water for taking another family's allotted time could be severe, involving heavy fines or even temporary expulsion from the irrigation collective. The law created a structure for cooperation where otherwise there would only be conflict. Royal decrees often extended to conservation. Chinese dynastic codes established protected forest zones, prohibiting the unauthorized cutting of timber to prevent erosion and preserve hunting grounds for the emperor. In ancient India, the Arthashastra outlined rules against polluting water sources, imposing fines on those who dumped waste into public reservoirs. These were not isolated edicts but part of a comprehensive legal view that the environment was a public good requiring state protection. Imagine two farmers' brothers in a Mesopotamian village facing a scorching summer. The younger brother, Enki, believes his older sibling, Adad, is using more than his share of water from their shared canal under the cover of night. Instead of a confrontation with hose and fists, Enki brings his complaint before the village elders. They consult the local water allocation roster, a legal document based on royal code, and dispatch a witness to observe the canal gates. Adad is found to have violated the schedule. The elders do not demand violence. They order him to forfeit his next 2 water turns to his brother, a penalty that directly repairs the harm and reinforces the rule of law. This entire system was built on a profound ecological wisdom, an understanding that the health of the society was inextricably linked to the health of its land and water. When you read about modern water rights disputes or international treaties on carbon emissions, can you see the ancient roots of using law to mediate our relationship with the planet? This same legal machinery that allocated water and protected forests was also the framework that organized a community for its most fundamental duty, its own defense. A citizen of Athens did not merely hope for protection from invaders. He was legally obligated to become the protector. The law carved his military duty into stone, specifying the armor he must afford based on his wealth, the length of his campaign service, and the precise share of spoils he could claim from a conquered city. This 15th principle, the legal codification of defense, transformed the abstract concept of security into a concrete, legally enforceable civic contract. Military historians note that these laws were the bedrock of state survival, converting a population into a predictable, organized fighting force. The Roman system was particularly meticulous. A legionary's term of service, his pay, and the land grant he would receive upon honorable discharge were all matters of statute, not the whim of a general. This legal promise of a future farm after 25 years of service was a powerful incentive, binding the soldier's personal future to the empire's expansion. Conversely, the penalties for desertion were severe and standardized, often execution or sale into slavery, a stark reminder that the law's protection came with its uncompromising demands. Exemptions existed but were narrowly defined, often for men who owned essential businesses or served in critical civic roles, demonstrating the state's careful balancing of military needs with economic stability. The Assyrian military codes were equally rigorous, legally mandating constant training and equipment inspections to maintain a state of readiness. This extended to the very infrastructure of defense, with laws requiring communities to maintain and garrison local fortifications. The treatment of prisoners, while often harsh, was also sometimes regulated, with codes specifying who could be enslaved and under what conditions, adding a layer of procedure to the brutality of war. Consider the story of a Roman veteran, Gaius, returning home after his long service. He presents his official discharge diploma, a bronze tablet inscribed with the emperor's seal, to the local magistrate. The law then compels the allocation to him of a parcel of public land, a tangible reward for his decades of sacrifice. This grant does more than feed his family. It turns a soldier into a settled, tax-paying landowner, weaving him back into the fabric of the society he defended. His personal security, legally guaranteed, becomes the foundation for continued community stability. How do the promises made to modern soldiers, from educational benefits to healthcare, reflect this ancient legal bargain between the individual and the state? The laws that governed armies clashing on battlefields, however, also had to account for the fragile moments of peace between them, giving rise to the earliest frameworks for international diplomacy. The same legal codes that organized armies for war also created the fragile architecture for peace. Rival empires did not communicate through shouts on a battlefield, but through carefully worded treaties inscribed on silver tablets and clay. These were the first stirrings of international law, a system of mutual obligation that recognized even bitter enemies were bound by shared rules. The famed peace treaty between the Hittites and Egyptians, negotiated after the stalemate at Kadesh, did not rely on trust. It was a detailed legal document specifying non-aggression, mutual defense against third parties, and the extradition of political fugitives. It treated the pharaoh and the Hittite king as equals under the law, a revolutionary concept that transformed a temporary truce into a durable framework for coexistence. Scholars of international relations point to these treaties as a critical innovation, using written agreements to create predictability and reduce the constant threat of warfare between complex states. This legal thinking extended to the very procedures of diplomacy. In Rome, the official priests were not just religious figures, they were living law. They followed a strict legal ritual for declaring war, ensuring it was seen as a just response to a violation of rights rather than mere aggression. They also oversaw the forging of alliances, their ceremonies giving divine and legal sanction to pacts with foreign powers. The law provided a script for interaction, even between strangers. Maritime codes, like those later developed by Rhodes, established universal rules of the sea. They defined what constituted piracy, a crime against all nations, and set out laws of neutrality to protect the ships of non-belligerent states during a conflict. A Phoenician merchant vessel sailing past a war between two Greek city-states could hope its declared neutrality, a legal status, would protect its cargo from seizure. On land, the treatment of foreigners was equally regulated. A trade caravan traveling from Assyria to Anatolia did not journey into a lawless void. Legal codes in both empires contained provisions for the safe passage of merchants, outlining their rights and the procedures if they were robbed or murdered within a host kingdom's borders. The king was legally responsible for the safety of travelers on his royal road, an early form of state liability. Imagine a specific caravan master, a man named Siduri, leading his donkeys laden with tin and textiles into a foreign city. At the gate, he presents his travel documents issued under a treaty his king signed. He pays the agreed-upon import duties at a standardized rate, another treaty provision. When a local official tries to demand a larger, unofficial bribe, Siduri calmly points to the public stele where the treaty terms are displayed. His argument is not based on his own strength, but on the weight of a legal agreement between two powerful states. His safety and his profit depend on this framework of international law. How much of the modern global order, from trade agreements to the Geneva Conventions, is built upon this ancient foundation of written pacts between sovereign powers? These intricate treaties, however, were only as strong as the evidence used to prove they had been broken, drawing us into the final, foundational layer of all ancient justice, the law of evidence and procedure. A merchant's word alone was not enough to win a case in an ancient courtroom. He had to prove it. This 17th principle, the meticulous framework of legal procedures and evidence, transformed justice from a matter of brute force or superstition into a structured search for truth. Long before forensic science, these codes established the very rules of the game, dictating who could speak, what they could say, and how a judge should weigh their words. The goal was to replace chaos with a predictable process, creating a shield against false convictions and arbitrary power. In the courts of ancient Athens, for example, a single witness was rarely sufficient. The law often required multiple, corroborating testimonies to establish a fact, a principle that recognized human fallibility and the danger of lies. Witnesses testified under solemn oath, invoking divine wrath against perjury, a powerful psychological deterrent in a deeply religious society. But the law's evolution is clearest in its slow turn away from supernatural tests. Early Germanic law relied heavily on ordeals like carrying a red-hot iron, where a cleanly healing wound was taken as a sign of divine favor and innocence. This was justice outsourced to the gods. Over centuries, this gave way to more rational evidence standards, particularly in Roman law with its formulary procedure, where a magistrate would define the precise legal issue in writing before a judge evaluated the facts. This separation of legal questions from factual ones was a profound step toward a modern, rational legal system. The burden of proof was a pivotal concept. In a dispute over a loan, the burden fell on the lender to prove the debt existed, not on the borrower to prove he had paid. This protected the weaker party from baseless claims. Documentary evidence became king in commercial societies. A contract written on papyrus or a clay tablet, signed by witnesses, was often irrefutable. Imagine a specific case in Babylon. A merchant, Ilu-Isiya, sues his business partner, claiming the man owes him 30 shekels of silver from a joint venture. The partner denies it. In court, Ilu-Isiya does not just plead. He produces a crisp clay tablet, imprinted with both their seals and the marks of 3 upstanding citizens who witnessed the agreement. He calls those witnesses to stand before the judge and confirm the terms. The case is decided not on charisma or social status, but on the strength of that documented evidence. The code's reliance on this paperwork created an entire ecosystem of scribes and notaries, the essential record keepers of commerce and justice. Appeals processes also existed, allowing a dissatisfied party to bring their case before a higher authority, perhaps a royal official or a larger council, if they believed the initial judges had erred. This created a crucial check on local corruption or incompetence. How many of our own legal safeguards, from the right to confront your accuser to the standard of proof beyond a reasonable doubt, are refined echoes of these ancient attempts to build a fair process? This intricate architecture of procedure did not remain frozen in stone, however. It had to bend and adapt as empires rose, cultures merged, and new forms of injustice emerged, leading to the final, enduring principle of all legal systems. A law code carved in stone was never truly set in stone. The most enduring legal systems were not static monuments but living, breathing entities that evolved with the societies they governed. When a new technology like coined money swept across the Mediterranean, the law had to adapt, creating rules for minting, counterfeiting, and commercial exchange that had been unimaginable in a barter economy. This capacity for innovation and adaptation was the 18th and final pillar of ancient legal architecture, ensuring that justice could meet the challenges of a changing world. Legal historians often describe this as the dynamic nature of law, a system that must grow or risk becoming irrelevant. We see this clearly in the Roman institution of the praetor's edict. Each year, the new praetor, a senior judicial official, would issue an edict announcing the legal principles he would follow during his term. While he respected traditional statutes, he could also introduce new remedies for injustices that existing law failed to address. This annual update cycle allowed Roman law to evolve pragmatically, incorporating new precedents and social expectations without having to rewrite the entire legal code from scratch. The mechanisms for change were as varied as the cultures themselves. A king might issue a sweeping reform decree, like the Mesopotamian Mizraim Acts that cancelled debts to prevent social collapse. A Greek popular assembly could debate and pass new statutes to reflect the will of the citizenry in a democracy, or scholarly interpretation, as seen in the great Byzantine revisions of Roman law under Emperor Justinian, could synthesize centuries of legal thought into a coherent new body of work. Consider a specific crisis. A prolonged famine strikes a region, leaving countless small farmers unable to pay their debts to wealthy lenders. The existing law is clear: defaulting debtors can be forced into servitude. But faced with the prospect of mass enslavement and social revolt, the king intervenes. He issues a royal decree, a legal amendment that suspends debt collection for a year and mandates the release of all debt slaves. This is not a betrayal of the law, but its fulfillment, using legal innovation to restore balance and prevent the total disintegration of the community. The law proved its worth not by remaining unchanged, but by responding to human need. Foreign influences also spurred legal evolution. When Rome conquered Greece, it did not simply impose its own laws, it absorbed Greek philosophical ideas about natural law and justice, which in turn refined Roman legal theory. This cross-pollination of ideas created a more sophisticated and universal jurisprudence. Can you see the parallel in our own time, as legal systems around the world now struggle to adapt to digital privacy, artificial intelligence, and genetic engineering? The ancient lesson is that the law's greatest strength is its ability to learn. This legacy of specific, adaptable codes from Hammurabi to Justinian did not vanish with the empires that created them. They were copied, translated, and studied, becoming the foundational texts that would one day inspire the legal systems of the modern world. A modern courtroom argument can rest on a principle first carved in stone 4,000 years ago. The shadow of Hammurabi's code stretches across continents and centuries, its core ideas echoing in everything from your mortgage agreement to the structure of international law. When archaeologists unearthed the black diorite stele in 1901, they did not just discover an ancient artifact, they recovered a foundational blueprint for justice that would inspire legal thinkers for millennia. The code's most famous contribution, the principle of an eye for an eye, was a radical limitation on vengeance that laid the groundwork for proportional punishment in Roman law and later in the legal traditions of Europe. But its structural genius went far deeper than retribution. The very idea of organizing laws into a comprehensive, public, and written body became the model for Roman jurists compiling the 12 tables and for the great codification projects of the Byzantine Emperor Justinian. Islamic jurists developing Sharia law were influenced by its meticulous categorization of crimes and its detailed provisions for commercial transactions and family matters, creating their own sophisticated systems of contract and inheritance. Comparative law scholars point to this as a story of intellectual migration, where a Mesopotamian template for a just society was adapted, refined, and reborn across different cultures. Consider the journey of a specific legal concept, the builder's liability. A clause in Hammurabi's code states that if a builder constructs a house poorly and it collapses, killing the owner's son, then the builder's own son shall be put to death. While the harshness is alien to us, the underlying principle of professional responsibility is not. A legal historian can trace a direct line from that ancient clause to a modern lawsuit where a family sues a construction firm for negligence after a faulty balcony railing leads to a tragic injury. The core idea that a professional is accountable for the safety and quality of their work and must provide compensation for failure was first given legal force on that Babylonian stele. The code's provisions on family law, detailing marriage as a binding contract with specific financial obligations for divorce, prefigure the prenuptial agreements and alimony arrangements of today. Its rules for witnesses and evidence created the procedural backbone that would become central to courtroom practice everywhere. How many of the laws that govern your daily transactions and relationships have distant origins in that single, ambitious document? This enduring legacy was not a matter of chance, but a testament to the code's profound practicality. Its rediscovery in the modern era gave scholars a Rosetta Stone for understanding the deep history of law, revealing how ancient minds grappled with the same fundamental problems of fairness, order, and human conflict that we still face. The continuous thread running from Babylon to the present day sets the stage for another legal superpower whose innovations would forever change the Western world. Roman jurists did not merely recite laws, they forged a new legal reality in the bustling forum. Their debates gave rise to a system so sophisticated that its bones still support the legal structures of nations across the globe. It began with the 12 Tables, a set of laws inscribed on bronze around 450 BCE and displayed publicly in the Roman Forum. This act mirrored Hammurabi's stele, establishing that justice must be accessible and known to all citizens, patrician and plebeian alike. But Rome's true genius was its legal evolution, a 500-year journey that culminated in the Corpus Juris Civilis, the body of civil law, compiled under the Byzantine Emperor Justinian in the 6th century. This monumental work preserved and systematized centuries of Roman legal wisdom, from the edicts of praetors to the opinions of great jurists like Gaius and Ulpian. Their writings codified principles we now take for granted, including the foundational idea that a person is considered innocent until proven guilty. This shifted the burden of proof onto the accuser, protecting individuals from the power of the state and creating a cornerstone of modern justice. The jurists were the engine of this system. They were not just judges but legal scientists who analyzed cases, wrote extensive commentaries, and developed a flexible framework of equity. Their work created a law that could adapt to new situations, from complex maritime trade disputes to intricate inheritance cases, ensuring its relevance across a vast and culturally diverse empire. This adaptability was key to Rome's success, allowing its legal system to be implanted in provinces from Britain to Syria. A merchant in Roman Britain operated under the same basic contract law as a shipowner in Alexandria, creating unprecedented stability for commerce. The law standardized sales contracts, leases, and business partnerships, detailing everything from the transfer of property ownership to the warranties on sold goods. This legal predictability fueled economic growth and connected the empire. Consider the case of Lucius, a common farmer in a provincial town like Pompeii. He inherits a small plot from his father, but a wealthy local landowner, Marcus, claims the land is rightfully his, citing an old, ambiguous family agreement. In an earlier time, Lucius would have been powerless against such an influential man, but under Roman law, he takes his land deed to a local jurist. The jurist reviews the case based on the established principles of property rights and documentary evidence. Marcus, as the accuser, is forced to prove his claim. When he cannot produce a valid contract or reliable witnesses, the case is dismissed. Lucius keeps his land, protected not by his own strength, but by the impartial power of Roman legal procedure. This accessibility for common citizens was a revolutionary force. How often does the principle of innocent until proven guilty surface in news reports or courtroom dramas you see today? The legacy of Roman law did not fade with the empire. It was rediscovered and studied in medieval European universities, becoming the bedrock of the civil law systems that govern most of continental Europe, Latin America, and beyond. Its logical structure and comprehensive nature provided a ready-made blueprint for modern nations. When you sign a rental agreement or file a small claims lawsuit, you are participating in a system refined by Roman jurists 2,000 years ago. Their revolution was in creating a law of reason, a living system that sought justice through procedure and principle, a powerful inheritance that would eventually be challenged by a new vision of law emerging from the desert. Across the Mediterranean, another legal superpower refined justice with philosophical precision. The Greeks wove law directly into the fabric of civic life, creating a system where the citizen's voice was the ultimate authority. In the heart of Athens, the law courts were not presided over by a professional judge, but by massive juries of 500 or more citizens chosen by lot. Every free male citizen was both the governed and the governor, expected to participate directly in the administration of justice. This radical democracy extended to lawmaking itself, where the popular assembly could debate and pass new decrees that reflected the collective will. The Athenian emphasis was not on a king's command, but on the rule of law as an expression of the community itself. Yet this system had its own hierarchies and exclusions, largely denying women, foreigners, and enslaved people a legal voice. The philosopher Aristotle famously defined the citizen as one who shares in the administration of justice, a definition that carved a sharp legal line between those who belonged and those who did not. How does this ancient ideal of direct participation compare to your own role in the legal system today? While Greek law celebrated the citizen's voice, a parallel tradition emerging from the deserts of the Near East would ground its legal authority in a divine covenant, creating a system that would influence billions. The Hebrew law, centered on the Torah, presented a powerful fusion of moral duty and civil statute. Here, the law was not a human invention but a gift from God, a comprehensive guide for creating a holy and just society. The Ten Commandments provided a foundational moral code, but the legal detail extended into every corner of life, from dietary restrictions and agricultural practices to detailed rules for social welfare. A striking provision mandated leaving the edges of a field unharvested so the poor and the foreigner could glean food, legally encoding compassion into the economic system. The law also established cities of refuge, providing sanctuary for someone who committed accidental manslaughter, a profound recognition of the difference between intent and tragedy. This system created a legal identity deeply tied to a shared spiritual purpose, an idea that would travel across centuries and continents. Can you see how the very concept of a law having a moral foundation beyond mere practical order stems from such ancient roots? This divine framework was not isolated. Far to the east in ancient India, the laws of Manu constructed an entire society around the concept of dharma, or sacred duty. This code prescribed different laws for the four main social classes, from priests to laborers, governing everything from marriage and diet to criminal punishments. Its goal was to maintain cosmic and social harmony through the precise fulfillment of one's ordained role. In China, legalist philosophers like Han Fei argued for a different kind of order, one based on strict, impersonal laws applied uniformly to ensure state power and stability. The Qin dynasty used this philosophy to brutally unify China, standardizing weights, measures, and even the axle widths of carts through relentless legal decree. Yet another tradition, Confucianism, emphasized moral example and social harmony over punitive statutes, believing that a virtuous ruler would inspire righteous conduct naturally. These were not just different rules, they were different visions of what law was for. Was it to enforce duty, to project power, or to cultivate virtue? Across the ocean, in the Andes, the Inca Empire managed millions without a written script, using knotted quipu cords as legal and administrative records to allocate labor and resources across a vast territory. Their law was oriented toward the collective, the ilu, or community, with land owned communally and work organized for the common good. A village adhering to these traditional codes long after the empire's fall shows the resilience of such communal legal structures. How does the legal philosophy you live under shape your own sense of responsibility to your community? This global tapestry of ancient law reveals that our modern legal world is a patchwork of these diverse traditions, a heritage now permanently altered by a single technological revolution, the invention of writing. The hand that held the stylus held more power than the soldier's spear. A scribe's careful etching transformed fleeting words into permanent commands, creating a legal reality that could travel across time and space. This was the quiet revolution of writing, the technology that turned spoken custom into unchangeable statute. Before written codes, law lived in the memories of elders and the rulings of chieftains, shifting with each retelling. Writing froze it in place. A law inscribed on a clay tablet in the royal court of Babylon could be copied and sent to a provincial governor hundreds of miles away, ensuring the same standard of justice was applied throughout the empire. This was the birth of legal consistency. The materials themselves shaped the law's character. Durable clay tablets in Mesopotamia recorded sales and contracts, their cuneiform indentations creating a permanent, tamper-proof record. In Egypt, scribes used papyrus, a lighter medium that allowed for longer, more complex legal scrolls to be stored in temple archives and carried by officials. The very physicality of these documents lent authority to the words they contained. A legal historian of literacy notes that this shift reduced the ambiguities of oral tradition, but it also created a new social divide. Those who could read the codes, the scribes and priests, gained immense influence, becoming the gatekeepers of justice in a largely illiterate world. The training of these scribes was a rigorous legal education in itself. In the tablet houses of Mesopotamia, students spent years mastering the intricate cuneiform script and copying standard legal formulas for contracts, wills, and court judgments. Their work was not creative, it was about perfect replication, ensuring that the law's language remained precise and unchanging across generations. This standardized legal language, filled with specific terms and formal phrases, began to develop, creating a professional jargon that separated legal procedure from everyday speech. A young student, let us call him Enlil, spends his days in a sun-baked courtyard, his hands cramping as he practices the phrase for a boundary dispute settlement over and over on a lump of wet clay. His teacher circles, correcting a single misplaced wedge that could alter the entire meaning of a clause. Enlil is not just learning to write, he is learning to build the immutable framework of his society. The spread of written law was often a direct result of conquest. An Egyptian pharaoh's decrees, carved in hieroglyphs on temple walls from Nubia to the Delta, were a powerful assertion of control, imposing a single legal standard on a diverse population. The very act of making people live under a written code they could not read was a profound demonstration of state power. Can you see the parallel in our own digital revolution, where the ability to code and understand complex terms of service agreements creates a new kind of literacy that empowers some and leaves others behind? This ancient link between writing and the law did not just preserve power, it also created a narrow path for a different kind of authority, one based on knowledge rather than birth, subtly influencing the possibilities for social mobility. The law could be a cage of rigid hierarchy, but it also held the keys. For a slave in ancient Rome, the most precious key was the legal act of manumission, a formal ceremony that transformed human property into a citizen. This was not a gift of kindness, but a complex legal process defined by statute. A master could free a slave in his will or before witnesses, granting not just liberty but the coveted status of a Roman citizen, complete with the right to vote and own property. This legal pathway created a surprising social fluidity where a former slave could become a wealthy merchant, his son a respected soldier, and his grandson a senator. The law did not erase the stigma of servitude, but it provided a documented, state-sanctioned ladder out of it. Similarly, in ancient China, the imperial examination system was a legal mechanism designed to identify talent. A brilliant farmer's son, through years of grueling study of the legal and philosophical classics, could sit for a state-mandated exam. If he passed, the law required his appointment as a government official, bypassing the privileges of noble birth and elevating him based on demonstrated merit. Historians point to this as one of the earliest attempts to use law to create a true meritocracy, channeling ambition into state service rather than rebellion. Even in the strict class systems of Mesopotamia, the law offered narrow avenues for advancement. A merchant who successfully financed large trading expeditions could accumulate enough wealth to petition for privileges typically reserved for the elite, such as exemption from certain labor duties. His success was protected by commercial law, and that very success could, in turn, bend the social laws in his favor. But these pathways were fraught with legal peril. The penalties for status fraud were severe. In Rome, a freedman who attempted to marry into a senatorial family could face exile or worse. In Byzantium, laws meticulously regulated the dress and behavior of different social classes, making any unauthorized attempt to appear more noble a punishable offense. The legal system was a double-edged sword, simultaneously creating channels for mobility while fiercely policing the boundaries of class. Consider the story of a young man, the son of a Mesopotamian farmer. He shows an aptitude for numbers, and his father uses a rare good harvest to pay a scribe to teach him. The boy masters cuneiform, the written language of the law. He is not born into the scribble class, but he enters it through a legally recognized education. He becomes a clerk in a temple archive, his new status defined by his skill and his legal appointment, not his father's occupation. His life is a testament to the law's potential to rewire destiny. How much of the promise of equal opportunity in our own societies depends on similar legal frameworks that aim to make talent, not birth, the engine of advancement? These laws governing individual status were just one part of a larger system designed to manage the most fundamental resource of all, the health and safety of the entire community. The sun has not yet risen over the city walls, but the potter, Damu, is already thinking about the law. His first stop is the noisy, pre-dawn marketplace, where he must hire a strong youth to help him gather clay from the riverbank. He does not simply shake hands with the boy's father. They find a scribe at his small stall, and for a small fee, the man etches a contract onto a damp clay tablet. The document specifies the boy's wage in barley, his hours of labor, and the penalty if he carelessly breaks a finished pot before delivery. This is not an option, it is the standard procedure, the only way Damu can secure labor and protect his fragile goods. The law is already at work, structuring his economic life before his hands even touch the wet clay. Later, as he transports his wares to a merchant's stall, his cartwheel accidentally clips the corner of a neighbor's drying rack, splintering the wood. In another time, this might have sparked a shouting match or a prolonged feud. Here, the outcome is already written. They both know the code's provision for such accidental damage. After a brief, tense discussion, they agree on a compensation price of 5 measures of barley, a sum dictated by custom and recorded law. The dispute is settled in minutes, not days, because the law provides a clear, pre-established price for the mishap. This is the burden and the benefit of legal compliance for the commoner, a life punctuated by small, legally defined interactions. Historians note that this pervasive legal framework, while restrictive, offered a profound benefit to people like Damu: predictability. He could plan his business, secure in the knowledge that his contracts would be honored and his minor disputes resolved without violence. His wife's day is equally governed by statutes. A trip to the market involves using the official stone weights to ensure she receives the correct amount of grain for her copper ring. The prices themselves might be influenced by royal decrees aimed at preventing famine. At home, her authority over the household servants is both granted and limited by the law, which outlines their rights and her responsibilities as the mistress of the house. Even the inheritance of Damu's small workshop is not a matter of his personal wish. The codes dictate that his eldest son will inherit the bulk of the business, while his daughter will receive a dowry to secure her marriage. This legal destiny for his children is something he has known and planned for since their birth. As evening falls, the community itself becomes the enforcer. The elders gather at the city gate, not as a formal court but as a daily clearinghouse for minor grievances. A farmer complains that his neighbor's sheep broke through a poorly maintained fence. The elders do not invent a solution. They recall the relevant clause from the public stele and suggest a fair compensation based on the number of animals and the value of the trampled crop. The law lives not just on the monument, but in the collective memory of the people. Could you navigate your own day if every transaction, from your morning coffee to your evening commute, required a signed contract and was subject to the public judgment of your neighbors? This intricate web of rules, burdensome as it might seem, was the invisible architecture that held ancient society together, a system of remarkable complexity that was about to face its greatest challenge: the collapse of the empires that created it and the long, uncertain journey toward the modern world. The fall of Rome did not erase its laws. Instead, its legal wreckage mixed with the customs of Germanic tribes and the growing power of the Christian Church, creating a complex new legal soil across Europe. In this medieval melting pot, a king's authority was no longer absolute. In 1215, English barons forced King John to sign the Magna Carta, a document that drew deeply on ancient ideas of lawful process. Its famous clause that no free man could be imprisoned or stripped of his rights except by the lawful judgment of his peers was a direct echo of the Roman right to a hearing. This was not a new invention, but the rediscovery of a principle that had been carved into stone millennia earlier. Legal scholars at new universities in Bologna and Paris began to study rediscovered copies of Justinian's Roman law code, treating it as the perfected written reason that could bring order to a fractured world. Their scholarly work, known as the civil law tradition, became the foundation for the legal systems of most of continental Europe. At the same time, in English royal courts, a different system was taking root. Judges began traveling circuits, making rulings based not on a single written code, but on previous judicial decisions and local customs. This became the common law, a system built layer by layer on precedent, yet it still upheld ancient Roman concepts like the paramount importance of property rights and the enforcement of contracts. The great legal theorist Henry de Bracton would write in the 13th century that law is the art of the good and the fair, a definition that would have felt familiar to both a Roman jurist and a Babylonian scribe. This continuity stretched beyond Christendom. Islamic Sharia law, developing in the same centuries, incorporated and refined legal concepts from the Roman and Persian empires it had absorbed, creating its own sophisticated systems of contract, commercial law, and evidence that shared a common intellectual ancestry with the West. Consider a specific dispute in a medieval Italian town. Two merchants are in conflict over a shipment of wool that was lost when a river barge sank. The local feudal lord is inclined to simply split the loss, pleasing no one. But a scholar trained in Roman law at the University of Bologna is consulted. He references the ancient digests of Justinian, which contain detailed rules on carrier liability and acts of God. He argues that the barge owner is liable because he failed to properly maintain his vessel, a precedent established in Roman cases 800 years prior. The town council, persuaded by this timeless logic, rules against the barge owner. The ancient law, preserved on parchment, had just resolved a medieval dispute. Can you trace the lineage of your own nation's constitution or its basic commercial statutes back to these ancient and medieval roots? The principles of due process you take for granted, and the deeds that secure your home are part of a story that was written long before your country was even founded.